extended directly toward me as the words that would ultimately cost her $75,000 and years of her freedom left her mouth with a level of audacity that is genuinely difficult to overstate. "Maybe you should calm your hormones, Judge," she said. The room went silent in a way my gavel has almost never produced on its own. For a television moment, the conditions for virality were present. But I do not practice theater. I practice law. I work with evidence. And when she leveled a sexist, ageist taunt at this bench, she accomplished something she had not intended. She revealed the contempt that powered her entire operation. Brenda did not simply lose a single case. She was not merely embarrassed in front of millions of viewers. What unfolded in the minutes that followed was the dismantling of an enterprise. What I did in the 30 seconds after she spoke was not a spectacle designed for cameras. It was the judicial and investigative exposure of a criminal operation that had extracted $412,000 from vulnerable immigrant business owners, forced closures, and destroyed livelihoods. The legal record assembled in that courtroom set off federal criminal investigations across multiple states. It exposed a detailed playbook of organized extortion operating behind the language of civil rights advocacy, and it began the process of financial restitution for victims who had been bankrupted by carefully orchestrated campaigns of shame and reputational destruction. Let me tell you exactly what I told her, because the facts carried their own weight and the law demanded precision. "You have a playbook," I said, "and I have read it. The pattern does not leave room for misinterpretation. Identify small businesses owned by immigrants who cannot afford to defend themselves in court. Present accommodation demands that would cost thousands of dollars to satisfy. Record the refusal using hidden cameras. File a lawsuit claiming discrimination under federal and state statutes. Launch a coordinated campaign of negative reviews and media pressure. Then offer a settlement for an amount between $8,000 and $15,000, a figure chosen specifically because it sits just below the cost of mounting a defense through trial. That arithmetic is cruelty converted into a revenue model." Brenda had refined the mechanics of it with considerable care. A failed attempt at law school, 8 years spent as a paralegal, and an instinctive grasp of how expensive litigation becomes for those without resources had taught her exactly how fear could be priced and sold. She located physicians willing to sign off on dubious medical claims for payment. She recruited people to play scripted witnesses. She built digital templates for defamatory reviews that could be deployed quickly. She packaged a coaching product that taught others how to replicate the scheme. She retained counsel who drafted complaints in language precisely calibrated to maximize panic in a small business owner with no legal background. The operation was precise, scalable, profitable, and thoroughly industrial in its design. But she had overlooked a fundamental truth. When criminal intent exists, the law accumulates a trail. Patterns leave fingerprints. And one of her intended victims, a woman named Linda Cho, refused to accept the role of anonymous casualty. Linda was 39 years old, an immigrant who had worked and saved for 15 years to open a small wellness spa. She refused the settlement. Instead, she undertook the laborious, expensive, and exhausting task that most victims simply cannot manage. She conducted research. She located the other victims. She retained a private investigator, and she assembled evidence that directly contradicted every theatrical claim Brenda had constructed. When Linda's investigator produced unedited footage of Brenda moving easily through a store, carrying groceries, pushing a shopping cart, and playing with her dog, the narrative of physical incapacity collapsed entirely. When documentary records revealed coordinated review campaigns, cascading complaint filings, and bank records suggesting an organized flow of settlement proceeds, the civil case demanded a considerably wider response. I do not pursue spectacle. I require proof. But proof arrived, and it accumulated steadily, building against a foundation of lies that could not sustain the weight. In court, I asked direct questions because soft questioning allows a practiced predator to read the room and adjust their answers accordingly. When I asked how many lawsuits she had filed, the response could not be permitted to remain vague. 47. When a scrolling timeline appeared on the screen displaying business names, filing dates, and settlement amounts, the architecture of the scheme became visible not only to the proprietors who had lived through it, but to the public watching in real time. When she rose from her mobility scooter, directly contradicting sworn medical affidavits submitted across dozens of filings, that single movement became a critical piece of documentary evidence that no subsequent explanation could neutralize. I explained to the courtroom the core of the matter. The Americans with Disabilities Act and equivalent state statutes exist to protect real people from genuine harm. They are not a licensing mechanism for extortion. When a plaintiff deploys disability claims as an instrument for extracting money through manufactured confrontations and coordinated attacks on a business's reputation, they have crossed from civil grievance into organized criminal conduct. Civil law provides remedies for injury. Criminal law addresses schemes designed to generate systematic profit through fraud. The law makes this distinction clearly, and so do I. I laid out for the courtroom what she had done in precise terms. She selected victims based on their vulnerability: immigrant ownership, thin profit margins, reputational exposure to sudden negative review campaigns. She applied coordinated pressure through hidden camera performances, carefully edited footage designed to tell a specific story, and waves of fabricated reviews engineered to appear organic. She assembled a network around her operation: paid witnesses, complicit physicians willing to provide false medical documentation, an attorney who produced complaints designed to terrify, and a digital marketplace instructing others in how to repeat the method. I have observed considerable misconduct from this bench across many years. This was organized, repeatable, and monetized at scale. When I referred the matter to federal authorities, I did so because the pattern strongly indicated interstate wire fraud, tax violations, and organized extortion. Referrals of this kind are not made casually. Federal investigative resources are not unlimited. Prosecutorial decisions carry serious weight. But when a documentary trail reveals repetitive filings across jurisdictions, traceable financial flows, fabricated documentation, and an active online instructional operation teaching replication, that is precisely the profile of case that federal investigators should pursue. And they did. Subpoenas followed, bank records were examined. The components of the larger picture fit together with an exactness that fabricated evidence cannot produce. What affected me personally was not the theatrical insult, though that conduct will never be tolerated in my courtroom. It was the human accounting. Small business owners had been financially ruined. Families had spent accumulated savings fighting manufactured litigation. Employees had lost positions. Marriages had deteriorated under the pressure, all of it so that one person could transform grievance into a revenue stream. The law was constructed to protect the vulnerable. She had turned it into a weapon, aimed directly at them. That I will not permit. The public response was immediate and intense because the television moment gave visible form to something many people had felt without being able to name. Outrage at the deliberate corruption of protections designed for the genuinely disadvantaged. But the legal result was not produced by public reaction. It required the careful assembly of admissible evidence, unedited surveillance footage with a verified and documented chain of custody, independent medical evaluation